here. Okay, and we are on. Welcome, folks, to week 3 of the course. It is September 7th, 2021, and everything is just fine. You will finish the American court system this week, and then you will learn about alternative dispute resolution, which is module 4. Your serial 1 assignment is due this Thursday. I got a couple questions from folks. It does not need to follow the IRAC format. This assignment is just for you guys to kind of get to know each other, put a little information about yourself together, and to form up that team. If you have group members that you've not been able to reach, please go ahead and look in the early modules. We have a whole module about group work and how to reach people through the messaging site in Icon. The other exciting thing that is going to be coming this week is I'll be posting the prompt for the ethics essay. And this year we're going to do something kind of cool and technical. It's based on an article that I read about facial recognition technology and the use of that to enforce lifetime bans of spectators at sporting events. But I think this technology has a lot of implications beyond sporting events. And so we will get into that, and we're going to ask you to write about the pros and cons, ethically speaking, of using this facial recognition technology and artificial intelligence. So that'll be kind of fun. Professor Dayton, there was a big decision, or rather non-decision, in the Supreme Court this week. Thoughts on this?
Yeah, so hopefully you know what Professor Osmanic's talking about. Regardless of what side you're on the issue, there are new things happening with respect to abortion in the United States right now. So Texas passed a heartbeat bill, basically no abortions after 6 weeks. There's one exception, I believe, for the health of the mother, but that's it. Typically, that is much more restrictive than what's historically been allowed under Roe versus Wade. And so historically, any sort of law like this that went up to the Supreme Court, it got enjoined, and maybe the Supreme Court heard about it or not, but it got overturned and was enjoined in the meantime. So it wasn't enforceable in the meantime. And the Supreme Court right now has decided not to enjoin it until presumably they hear the case. So that's a big deal. That's definitely different than what the Supreme Court has done in the recent past. And you should keep up on it. You should read about it, go to the SCOTUS blog, find it, be conversant about it. It's going to be a very big deal, and people have lots of opinions, which means there'll be a lot of uninformed opinions about it. But you get to know the intricacies of the law and the constitutional law right now, because it could be very different. And if you really want to get into a rabbit hole, which is what Professor Hasmanic loves to do, you can look back over the presidential elections, the last 4, 5, 6 years, what Senator Grassley did, I'll say blocking, but not allowing Obama to make a judicial appointment. And a lot of it had to do with this issue. A lot of Republican voters were voting on this particular issue, making sure there was a president in the White House who would appoint certain Supreme Court justices to reconsider Roe versus Wade. So you're seeing it real time. And again, you don't try to discern our opinions based on what we're saying here. We just want you to be informed of what's going on. And so please look into it.
Yeah, I will post a link in the description below to a very good SCOTUS blog analysis of this. So SCOTUS blog is one of my favorite sources for everything about the Supreme Court. They have really well-informed writers who are lawyers typically, and I think they play it down the middle, and they also disclose if they have any conflicts of interest or their firms are involved in the case at all, which I think is good and appropriate. One of the interesting and unusual things about this law is that it seeks to avoid the state actor doctrine by appointing or allowing private individuals to sue on their own behalf, and establishes an award of $10,000 for anyone who sues anyone who provides, aids, or abets an abortion. So this is a really unusual kind of law. The only thing I can really think of that's quite sort of similar would be qui tam lawsuits, or certain whistleblower cases where you get a percentage of the recovery if the government is being defrauded. But this deputizes private individuals to do the suing, and so it seeks to circumvent the state actor doctrine. The court declined to issue an emergency injunction against the law. So that's very different than saying the law is okay or the law is constitutional. They did not pass on the merits of the case, but they are going to let it work its way up through the lower courts rather than immediately enjoining it. It has had the effect of basically stopping all abortion providers in Texas the day it went into effect, which was September 1st. So again, very big case. Like Professor Dayton said, a lot of information and a lot of bad opinions out there. SCOTUS blog is always going to be your friend for these cases to give you the best information. And also, I always advocate people go to the real documents themselves. So SCOTUS blog has the links to the order, to the dissents in this case, so you can go and read those yourself and make your own decisions. All right, well, folks, we are looking forward to another great week of class. As always, pop into office hours if you have any questions for us or the TAs. We hope you have a good week. We hope you stay healthy and safe, and we will see you next week. All right.